machines, and the members will record the roll. Has every member recorded their presence? The clerk will lock the machine and record the roll.
65 present.
65 present, 5 absent and excused. The majority being present, the House is ready to do business. Second order of business is prayer by the chaplain, followed by the Pledge of Allegiance. Will the members in the gallery please rise?
If you have long memories, you'll remember that I shared the first half of the Paradoxical Commandments yesterday by Ken Keats, so today's second half. The biggest men and women with the biggest ideas can be shot down by the smallest men and women with the smallest minds. Think big anyway. People favor underdogs but follow only top dogs. Fight for the few underdogs anyway. What you spend your years building may be destroyed overnight. Build anyway. People really need help but may attack you if you do help them. Help them anyway. Give the world the best you have and you'll get kicked in the teeth. Give the world the best you have anyway. Let's pray. Our dear Heavenly Father, what an honor it is to call upon you this day to lead us. I pray, dear Lord, that you would open up doors for us to be successful in our endeavors. Help us not to be discouraged by outside forces that sometimes try to derail us and derail our success. But help us to fight through it and pursue that which will lead Idaho to great things. I pray, dear Lord, that we would all do our best, even when the going gets tough. May we communicate openly and honestly with each other without taking offense. Give us a gentle spirit in dealing with the constituents and listen openly to their thoughts. Flood us with wisdom from on high in every part of our lives. Bless our military people and keep them safe. And may they recognize how much we as people love and appreciate them for the many sacrifices they make. I ask these things in Jesus' name. Amen.
I pledge allegiance
to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
The House will now advance to the third order of business, approval of the journal. The House is at the third order of business.
January 24th, 2013. Mr. Speaker, we, your Committee on Judiciary, Rules and Administration, report that we have read and approved the House Journal of the 17th Legislative Day and recommend same be adopted as corrected. Moved by Wills, seconded by Burgoyne.
You've heard the motion. All those in favor say aye. Those opposed say nay. The motion is passed. The House will now advance to the fourth order of business, consideration of messages from the Governor and the Senate. The House is at the fourth order of business.
From the Office of the Governor, a certificate of appointment. Know all men that pursuant to provisions of Section 59-917 Idaho Code, Steve Miller, State Representative, District 26, Seat A, Camas County, State of Idaho, has nominated Lee Barron to perform the duties of his office temporarily as Acting State Representative, District 26, Seat A. Now, therefore, I, C.L. Butch Otter, Governor of the State of Idaho, by the virtue of the authority vested in me, do hereby appoint Lee Barron of Corral, Idaho, to the office of Acting State Representative, District 26, Seat A, for a term commencing January 24, 2013, and continuing until such a time as Representative Miller is able to resume his duties. In testimony whereof, I have hereunto set my hand and caused to be affixed the Great Seal of the State of Idaho at the Capitol in Boise on this 22nd date of January in the year of our Lord 2013, and the independence of the United States of America in the 237th year by the Governor, C.L. Butch Otter, and Secretary of State, Ben Usursa.
The certificate for appointment for Representative Barron has been, for replacing Representative Miller, has been placed and filed in the Chief Clerk's office, and the oath was previously administered. Welcome, Representative Barron. Enjoy your time here. With that, the House will now advance to the fifth order of business, report of standing committees. The House is at the fifth order of business.
January 24th, 2013. Mr. Speaker, we, your Committee on Judiciary, Rules and Administration, report that we have printed House Concurrent Resolution 2, 3, and 4, and House Bills 31, 32, 33, 34, 35, 36, 37, 38, 39, 40, and 41.
House Concurrent Resolution 2, House Bill 37 will be referred to the Environment and Technology Committee. House Concurrent Resolution 3 will be referred to the Education Committee. House Bills 31, 32, 33, 34, 35, and 36 will be referred to the Health and Welfare Committee. House Bills 38 will be referred to the Resource and Conservation Committee. House Bills 39, 40, and 41 will be referred to the Transportation Committee. House Concurrent Resolution 4 will be filed for second reading. Without objection, the House will now advance the 8th order of business, introduction and first reading and references of bills and joint resolutions. The House is at the 8th order of business.
In the House of Representatives, House Bill number 42 by State Affairs Committee, an act relating to counties, amending Section 31, 126, and 31, of Lincoln County and Minidoka County, and to make technical corrections and declaring an emergency. House Bill number 43 by Commerce and Human Resources Committee, an act relating to the Economic Advisory Council for the Department of Commerce, amending Section 674704 Idaho Code to clarify that members of the Economic Advisory Council serve at the pleasure of the governor, and to provide that no more than 4 members of the Economic Advisory Council shall be from any one political party. House Bill number 44 by Commerce and Human Resources Committee, an act relating to employment security law, amending Chapter 13, Title 72 Idaho Code by the addition of new Section 72-1351B to prohibit certain relief from liability relating to benefits paid to a claimant that are subsequently determined to be overpaid, to provide conditions to clarify what constitutes a timely response, to provide for extended time limits, to clarify what constitutes an inadequate response, to clarify what constitutes a pattern of failure to respond timely and adequately, to provide for notification of the Department of Labor's determination, and to provide for appeal, amending Section 72-1369 to provide for the collection of civil penalties, to provide for the deposit of civil penalties to specified funds, and to limit the compromise of civil penalties, amending Section 72-1603 to revise the definition to make technical corrections and providing effective dates. House Bill number 45 by Business Committee, an act relating to engineers and surveyors, amending Section 54-1202 Idaho Code to define a term, to revise definitions, and to make technical correction, amending Section 54-1220 to revise provisions relating to the disciplinary actions and procedures, amending Section 54-1221 to revise provisions relating to the reissuance of licenses, to provide requirements relating to the reissuance of wall certificates, and to make a technical correction, and amending Section 54-1228 to provide correct terminology. House Bill number 46 by Business Committee, an act relating to fire escapes and doors, repealing Section 39-1901 relating to fire escapes provided for certain structures, repealing Section 39-1902 relating to how fire escapes are attached, repealing Section 39-1904 relating to the penalty for violations, and repealing Section 39-1905 relating to doors on public buildings. House Bill number 47 by Resources and Conservation Committee, an act relating to water masters, amending Section 42605 to authorize the Director of the Department of Water Resources to appoint a successor water master under certain conditions, and to provide a procedure. House Bill number 48 by Resources and Conservation Committee, an act relating to injection wells, amending Section 42-3908 to provide that the Director of the Department of Water Resources shall require good and sufficient security as a condition of every Class II interjection well permit, to provide for the form of security, to provide the basis for security, for the amount of security, to provide for the security shall be conditioned upon certain performance, to provide for the duration of the security, to provide that the well decommissioning shall include certain reclamation of the well site, and to authorize additional security requirements under certain circumstances. House Bill number 49 by Resources and Conservation Committee, an act relating to injection wells, amending Section 42-3902 Idaho Code to define Class II injection well, and amending Section 42-3905 to revise filing fee provisions, and to provide a filing fee for Class II injection wells. House Bill number 50 by Resources and Conservation Committee, an act relating to hydropower, amending Section 42-203B Idaho Code to revise provisions relating to the authority of the Director of the Idaho Department of Water Resources to limit a permit or license for power purposes to term, to provide that the term may be in certain forms, to revise an exception to applicability, to revise provisions relating to the consideration of certain factors regarding the Director's limitation of a permit or license to a term, to remove reference to a term of years, to provide that the term, once established, shall not be modified except in accordance with the due process of law prior to expiring, to provide for the automatic extension of a term with annual renewals of the project's Federal Energy Regulatory Commission license, to provide that the director may review such water right licenses and to issue certain orders prior to the issuance of a subsequent or new license, to provide for the effective date of such orders, to provide for automatic extension of terms where such order is not issued, and for the continued effectiveness of original conditions, to provide for the director's review of terms not established by reference to the project's license, to provide that the director may review such water right licenses and issue certain orders prior to expiration of the term, to provide for the effective date of such orders, to provide for the automatic extension of terms where such order is not issued, and for the continued effectiveness of original conditions, and to make a technical correction. House Bill number 51 by Revenue and Taxation Committee, an act relating to income taxation, amending Section 30, Title 63 Idaho Code by the addition of a new Section 633029L to define terms, to provide for certification, to provide for agriculture value-added income tax credit, to provide the taxable year for the agriculture value-added income tax credit, to provide procedures, to provide for investment reporting forms, to provide rules, and to provide application, declaring an emergency, providing retroactive application, and providing a sunset clause. House Bill number 52 by Revenue and Taxation Committee, an act relating to the Circuit Breaker Property Tax Relief Program, amending Section 63-713 Idaho Code to define a term, amending Section 63-714, 718, and 720 to revise provisions relating to recovery of erroneous and other improper deferrals, and to make a technical correction, declaring an emergency, and providing retroactive application.
House Bills 42 through 52 will be referred to the Judiciary and Rules and Administration Committee for printing. Without objection, the House will now advance the 10th order of business, second reading of bills and joint resolutions. The House is at the 10th order of business.
In the House of Representatives, House Bill 14 by Revenue and Taxation Committee regarding property taxation. House Bill 15 by Revenue and Taxation Committee regarding sales and use tax. House Bill 22 by Revenue and Taxation Committee regarding income taxation. House Bill 23 by Revenue and Taxation Committee regarding beer taxation.
House Bills 14, 15, 22, and 23 will be filed for third reading. The House will now advance to the 11th order of business, third reading of bills and joint resolutions. The House is at the 11th order of business. The House will have under consideration House Bill 2. Good gentleman from 25.
Mr. Speaker, I would make a motion that for unanimous consent to dispense with the reading of House Bill 2.
Unanimous consent has been requested. Is there objection? Hearing none, the gentleman has the floor.
Thank you, Mr. Speaker. Members of the House, House Bill 2, under current Idaho law, some losses, such as theft, are deductible only as an itemized deduction and are not allowed as part of an Idaho net operating loss, even though they are allowed on the federal return. This means that these losses may be fully deducted over 1 or more years on the federal returns, but only fully deducted on the Idaho return if the taxpayer has sufficient income in that year to claim that deduction. The problem arises when the taxpayer receives a recovery of all or part of the loss in subsequent years. The loss recovery is taxable on the federal income, as it should be, but this income then flows over to the Idaho return. And even though the underlying loss might not have been deducted in full or in part on the original Idaho return, the effect is that it's tax on phantom income because there was no deduction of that income. This bill corrects this unfairness by allowing a deduction for Idaho purposes an amount equal to the amount of the recovery if the taxpayer did not receive a deduction for the loss on a prior Idaho return. In other words, we don't want to tax the loss recovered if no benefit of the loss has been claimed. This bill does not increase the amount of loss deducted on an Idaho return, and the fiscal effect will reduce the general fund revenue by about $250,000, which represents $3.3 million in lost recoveries in 2013. Mr. Speaker, members of the House, this bill passed out of committee with a do-pass recommendation with no known opposition. Mr. Speaker, I would recommend that this bill be passed.
Thank you, good gentlemen. You heard the motion. Is there further debate? Oh, you got off easy. Debate is closed. Question is, shall House Bill 2 pass the House? The clerk will unlock the machine and the members will record the roll. Has every member voted?
McMillan? Okay. Woodings?
Representative Wooding?
Yeah, we got her.
Does any member wish to change their vote? The clerk will lock the machine and record the roll. 65 ayes, 1 nay, 4 absent and excused. The majority having voted in favor of House Bill 2. House Bill 2 has passed the House. Is there correction to title? Hearing none, the title is approved and the bill will be transmitted to the Senate. Good gentleman from 23.
Thank you, Mr. Speaker. I would like to recognize point of personal privilege first, if I may.
Gentleman has the floor.
I would like to recognize behind us we have a large number of district judges from throughout the state that are here in Boise this week, and they're here for the judiciary address later on. So if you would give them a warm welcome, thank you.
Welcome to the chamber. House will now have in consideration House Bill 3. Good gentleman from 31.
Mr. Speaker, I ask unanimous consent that further reading of House Bill 3 be dispensed with.
Unanimous consent has been requested. Is there objection? Hearing none, the good gentleman has the floor.
Mr. Speaker, I ask permission to read a few words of prepared text.
Unanimous consent has been requested to read. Is there objection? Hearing none, the good gentleman may read.
This bill was put forth to protect our citizens against identity theft. We're all aware that identity theft is a serious and growing problem across the country as well as here in our state. And an identity thief can steal a Social Security number, use that number to gain employment, and then file an Idaho income tax return. Despite the best efforts of the Tax Commission, the return could process through the system and a refund be issued. If the true owner of that Social Security number contacts the Tax Commission to complain, the Commission staff cannot respond. The intent of this bill is to allow the Tax Commission to respond and to provide the release of the identity thief's name and address as filed with them. Reclaiming one's identity is a daunting and difficult task. This bill can make the task a little easier. I recommend its passage, Mr. Speaker.
You've heard the motion. Is there further debate? Hearing none, debate is closed. The question is, shall House Bill 3 pass the House? The clerk will unlock the machine and the members record the roll. Has every member voted? Does any member wish to change their vote? Clerk will lock the machine and record the roll. 64 ayes, 66 ayes, 0 nays, 4 absent and excused. The majority having voted in favor of House Bill 3. House Bill 3 has passed the House. Is there correction to title? Hearing none, the title is approved and the bill will be transmitted to the Senate. House will now have under consideration House Bill 4. The gentleman from 16.
Thank you, Mr. Speaker. I request unanimous consent to dispense with the further reading of House Bill 4.
Unanimous consent has been requested. Is there objection? Hearing none, the good gentleman has the floor.
Thank you, Mr. Speaker. This bill comes to us from the Tax Commission also, and it makes technical corrections to the Idaho income tax. Section 1 of the bill, which begins on page 1, arises from House Bill 634, which was passed during the 2012 session. And it clarifies that the credit for taxes paid to other states, it clarifies that provision by making a reference to the correct code section. This change adds a cross-reference from Section 63-3029 to Section 63-3022 for clarity. Section 2 of the bill, which begins on page 3, arises from House Bill 364, which was passed during the 2012 session. It clarifies the deduction for retirement benefits paid to certain retired police officers and revises the definition of disabled and replaces the word widow with widow and widower. That's the 2012 legislation. However, not all of the references pertaining to gender were changed in the bill. So this bill changes and corrects Section 633022A to replace all mentions of the word widow with widower and widow, and adjusts other gender references. Section 3 of the bill begins on page 5. It arises from House Bill 485, passed in the 2012 session, which revised eligibility criteria for income tax deductions for installing energy-efficient upgrades to existing residences. Through an oversight, the drafters omitted a requirement that the residence be located in the state of Idaho and that the residence be the taxpayer's primary residence. The Commission discovered the omission during the rule writing process and discussed it with the bill sponsors. The bill sponsors agreed a change was needed, otherwise property outside of Idaho could qualify for the deduction. Now, all of the provisions of this bill take effect on January 1 of 2013 except Section 3, and that's because this energy deduction was in effect under the bill we passed in 2012 as of January 1, 2012. So this section of the bill, Section 3, needs to take effect on January 1, 2012. Section 4 begins on page 6. It clarifies the deduction for technology equipment donations is limited to the lesser of fair market value or cost. Some taxpayers buy equipment at a substantial discount below fair market value and then claim a higher fair market value as the deduction for their technological equipment donation. So the change is consistent with how other deductions are treated in the tax code. Section 5 of the bill begins on page 7, and it modifies Idaho Code Section 633072 relating to the statute of limitations for claiming a refund to include a reference to a new Idaho Code Section 6336B, which was enacted in 2012. This all relates to pass-through entities backup withholding. And finally, Section 6 of the bill provides the effective dates for the various sections, as I previously mentioned. The bill went through committee without opposition. No known opposition exists, and I urge you to, if you must, vote no and make me feel young, and then vote yes. Thank you.
You've heard the motion. Is there further debate? Hearing none. Debate is closed. The question is, shall House Bill 4 pass the House? The clerk will unlock the machine and the members will record the roll. Has every member voted? Does any member wish to change their vote? Clerk will lock the machine and record the roll. "65 ayes, 5 absent and excused, majority having voted in favor of House Bill 4. House Bill 4 is passed the House. Is there correction to title? Hearing none, the title is approved and the bill will be transmitted to the Senate. The gentleman from 13.
Mr. Speaker, I ask unanimous consent that the remaining bills on the third reading calendar hold their place one legislative day.
You've heard the motion. Is there objection? Hearing none, the remaining bills on the third reading calendar will be held in their place one legislative day. Without objection, the House will advance to the 15th order of business, announcements. The House is at the 15th order of business. Good gentleman from 13.
Thank you, Mr. Speaker. Just wanted to make an announcement that the members of the House State Affairs Committee, the buses will be out front at 11:30 to take you over to the Ada County Courthouse so you can see some of the voting procedures that take place over there.
Good lady from 26.
Thank you, Mr. Speaker. Announced that the Minority Caucus has a caucus meeting at 3:30 this afternoon.
Good lady from 33.
Mr. Speaker, I just have an announcement on the Valentines that are being passed out. This is in conjunction with Boise Radio 92.3. They asked the community for homemade Valentines, which they will be sending to our troops in Afghanistan. I felt that since we're in session, I would go ahead and make some homemade Valentines, which are being passed around. I will get them to the radio station tomorrow, and they will be sent over. And I can tell you, my son was in Iraq, and they really do appreciate anything from home.
Thank you, good lady. The Speaker will take a personal privilege right now. We're going to put the House at ease to hear the state of the judiciary from the Chief Justice. And so with that, the House will be at ease. Good gentlemen.
Indeed, my pleasure to introduce to you for the judiciary address the state, the Supreme Court Justice, Mr. Roger Purdy, and along with him, we also have the Supreme Court up there above, so we may introduce you. Thank you.
I'd like to welcome you, Chief Justice. We look forward to hearing what you have to say about the judiciary.
Very well.
The podium's yours.
Thank you. I always like an audience that claps before they even know what I'm going to say. So thank you very much. We hope you'll clap when I leave. Mr. Speaker, distinguished members of the Idaho House of Representatives, my colleagues on the Idaho State Supreme Court and Court of Appeals. In addition, we had at the same time our district judges conference, and we have seated in the gallery most, if not all, of the district judges in the state of Idaho. And I would like to thank them for their remarkable work, the remarkable product that you put out, the hours that you spend in trying to improve not only the judiciary, but all other agencies that touch the judiciary. We are very lucky to have each and every one of you. Thank you for attending. And I also bring greetings from Idaho's judiciary, who handled over 436,000 filed cases and over 655 filed appeals in 2012. I am proud to report to you on the performance and continued accountability of Idaho's third branch of government. Like many of you in this body, we rely heavily on evidence-based practices supported by quantifiable research. My remarks today will describe how the judiciary uses these in furtherance of its mission to provide justice through the timely, fair, and impartial resolution of Idaho citizens' cases. First are the efforts of our problem-solving courts. This is not business as usual. The problem-solving court model starts with intense supervision by a judge of a criminal or a civil case. This supervision is supported by a multidisciplinary team of experts with significant experience in the field. The problem-solving team monitors, educates, and recommends needed action until the participant complies with necessary requirements. This work necessitates increased analysis, judicial resources, and time, but by all quantifiable research works. The fact that it works can be seen in the expansion from drug courts to mental health courts, to domestic violence courts, to child protective courts, and now to veterans courts. All three branches of government have found this type of problem-solving team approach effective in saving counties and Idaho corrections dollars, keeping the community safe, and holding offenders accountable. Our goal of quantifiable results is also seen in our Advancing Justice Initiative. The Advancing Justice Initiative was begun to provide assurance that we do our business as efficiently as possible. In that regard, a court committee headed by Senior Judge Barry Wood has been analyzing Idaho's court system top to bottom. That work includes contacts with the Idaho Department of Corrections, law enforcement, attorneys, clerks, and judges, analyzing each and every case type which is filed in Idaho. This analysis has helped us identify inefficiencies and to see what court processes can be reformed to speed resolution of our citizens' problems. This is not an analysis that is aimed only at speed. It is, in fact, an analysis of quality. As a result of the data demands of this initiative, as well as the critical need to upgrade our statewide case management system, which you have thankfully supported since the 1980s, Idaho's courts have adopted a new vision for court technology. Our vision includes real-time data from every court in the state immediately available to every other court and to all other individuals and agencies who require access to court information. This real-time data transfer allows enforcement of court orders for the protection of victims and our communities. This capability will extend to every courthouse in Idaho, and we are now diligently working on the infrastructure necessary to support same. We also envision an expanded telepresence for litigants, attorneys, judges, and the public. Our magistrate and district judges traveled over 309,000 miles last year to preside over hearings in courtrooms throughout this state. By the use of advanced technology, mileage costs and travel time will be significantly reduced, with attendant court savings or cost savings to law enforcement. Just as private enterprise relies on telepresence to conduct business in the new economy, we will embrace this new technology and look for efficiencies it will provide. As part of our technological analysis, we are examining how better to collect fines, fees, and other obligations on a coordinated statewide basis. We know that can create efficiencies and save taxpayer dollars. Our technology plans were started by an in-depth analysis and assessment by 3 of the nation's foremost court technology experts. That assessment is now available on our website. We urge you to examine and read it. Following that assessment, a committee was formed to chart dynamic and broad policy decisions for the coming years concerning the use of technology for Idaho citizens. When I use the word dynamic, I think it's really an understatement. I've been in the judicial system as a judge of one sort or another for over 31 years. And I can never remember a time when Idaho's courts have been this responsive to citizens' needs and the accountability that goes along with it. And efforts are underway that will affect this judiciary for decades. And we anticipate coming to you next session with a more complete analysis of revenue options as our plans for electronic filing of court papers evolve. As we move to a paperless courthouse, we anticipate some of these improvements can be funded by court users, and there will be significant savings realized by counties and courts. As I reported last year, we have continued in our renewed effort to recruit the most qualified judges for our empty positions. We now hold an open discussion group in those counties in which district judges are being replaced. These discussion groups concern benefits of starting a career in the judiciary and to answer any and all questions about that career, as well as the application process itself. During Judicial Council interviews, we have heard numerous times from the applicants that they were encouraged by this opportunity to step forward and consider applying for a district judge position. Despite these and other efforts, we have a significant problem in recruiting district judges. The Judicial Council can rarely send a full slate of 4 names to the governor for appointment. In our surveys and interviews with bar members and judges, it has become apparent that the district judgeship is no longer a highly sought-after judicial position. The reasons are many. The overwhelming workload that these district judges face in terms of numbers as well as complexity. The prospect of contested elections, as well as inadequate compensation for the position. You might ask why potential applicants are so concerned with the prospect of contested elections. I mean, after all, each of us in this room faces a contested election. The legislature has wisely placed practice and age requirements on judicial candidates and applicants. The chosen attorney has built a clientele and professional relationships during that time period that must be completely terminated if they take that judicial position. If the judge loses a contested election, those clients are gone. The judge must start from scratch, replicating that prior book of business, whether it be in a large firm in Boise or in a one attorney shop in Jerome. The judge, when you factor then in the ethical considerations of a judge's conduct during the time they are a judge, fundraising restrictions, and the time away from a full judicial caseload during that election, you begin to understand the high stakes to a potential applicant and his or her family. While we have a judiciary that is nationally recognized for its commitment to excellence, performance, and accountability, Idaho ranks 46th in compensation for its general jurisdiction judges. We have recognized for many years there is a need to improve the salary of district judges so we can attract highly qualified private attorneys to that position. I think we can do better. We will be presenting a comprehensive analysis this session about the need to recruit the most qualified district judges. I reported last year that we were re-energizing our guardianships and conservatorships based upon and in reaction to the graying of America. Certainly none in this chamber, but some of us are. And did you know that the number of Idahoans 60 and older grew by 44% from 2000 to 2010? And from 2010 to 2030, it is estimated to increase by 65%. There are now over 6,200 guardianship and conservatorship cases in Idaho with over $300 million in assets that are being managed by court personnel. And this will only increase. I am pleased to report that the Guardianship and Conservatorship Committee, headed by Judge Chris Beater here in Ada County, has made significant progress. Idaho courts were singled out as a voting delegate to attend the 3rd National Guardianship Summit. We have fixed our vision for Idaho on evidence-based solutions, and we look forward to working with the legislative and executive branches to re-examine all statutes and court rules to make sure Idaho meets its responsibility to its oftentimes most vulnerable citizens. We are also requesting the legislature repeal the sunset provision of House Bill 687, which added an emergency surcharge to felony, misdemeanor, and traffic infractions. The general fund, I doubt, will be able to permit you to fill a funding gap of over $4 million. Since you enacted it in 2010, the emergency surcharge has kept the courthouse doors open in each of your counties and provided such beneficial programs as drug courts, mental health courts, and family courts. The repeal of the sunset provision is vital to the Idaho judiciary's constitutional role to solve people's disputes and to keep our communities safe. Even with the surcharge, the court was unable to to fill 4 judicial positions. We've now been able to replace 2 of those positions, and we wish to thank the county and court officials in those counties for their patience and willingness and ability to manage with senior retired judges during that time. We plan to replace the 2 remaining vacancies in September 2013 and early 2014. Numerous court employee positions, however, remain unfilled statewide, and there have been continuing significant reduction in court operations throughout the state. It is a bedrock function of government to properly fund a judicial system. A justice system based largely on user fees cannot continue to provide the requisite funds to protect our communities, nor timely resolve these complex civil cases. At some time, the debt load of offenders will not be able to fund the judicial system or the attendant agencies that rely on those fees for revenue. This is a recognition that is being debated in the judicial halls and in the state houses throughout the nation. And we as a state need to start monitoring it. Quite frankly, the word court costs is misleading. Did you know that 152 cities share $6.9 million in court costs yearly? 44 counties disperse $16.3 million in 23 different ways. State entities receive a total of $26.3 million. The general fund, $5 million. And other state entities, $21.3 million. These are in addition to the restitution ordered to the victims of crime. Now, this basket is about full, and Idaho must proceed carefully when adding to the court cost or fee basket. We hope that a statewide analysis through the Criminal Justice Commission will help you in this regard. And please excuse me. So how can you and other interested citizens follow a branch of government that is so dynamic, so bent on improvement? We promote openness and accountability through the expanded use of our website. All of you can immediately critique or read, whichever, our opinions as they are published by looking at our website. You can also Twitter us or follow us on Twitter if you wish to know where we are sitting a certain place at a certain time. And since August of 2012, the Supreme Court's Boise oral arguments are streamed on Idaho Public Television. I must admit the language has improved since then. I've heard many legislators say they use the district court and magistrate division case information available online in our judicial repository. And they, as well as we, understand it needs to be modernized. Court assistance, self-help information, and forms are available online as a partial answer to the large increase in the number of Idahoans who are proceeding in court without attorneys. Lastly, we invite all legislators to attend interviews in your home counties when the Judicial Council or your magistrate commissions interview new judicial candidates. In fact, Representative Eskridge attended those in Sandpoint just recently, found them very interesting, I think. And you can also find on the website all of the rules of the Idaho courts and any impending amendments to those, if you can't sleep at night. And I'd like to seriously recognize Judges Russell Comstock and David Day for their vision for specialized rules of procedure in family courts. They and a court committee worked diligently for 3 years on those rules, and we thank them. Their idea came to fruition when that committee's rules are now a pilot project in Ada County. near future, the legislature will consider, for the first time in many decades, an analysis of improving the public defender system in each of our counties. It is a basic tenet of our system to be fair to those persons brought before the court, accused by the state of crimes which may take their liberty, their reputation, and their purse. It can be argued that our statewide system of public defense for those citizens who cannot afford their own private attorney is not balanced throughout the state nor in the courtrooms of Idaho. The Governor's Criminal Justice Commission has made progress in identifying some of the areas that you will need to consider on a public policy basis. We leave it to your solemn analysis as to how Idaho can approach this problem in hopefully the near future. The Idaho Judiciary supports the appointment of an interim legislative committee to review these issues, and we pledge to support that committee with information upon which you can make these very important decisions. This is not an issue of guilty persons going free, but of Idaho citizens sharing in a criminal justice system that is fair to all concerned. As a final note, none of this work can be done without the numerous county clerks, bailiffs, attorneys, and others who provide the administration arm of the courts. This statewide collection of professionals is guided by Patty Tobias, the administrative director of our courts. Many of you know her as a true professional and a friend. Now she has been appropriately awarded the nation's highest honor. This month, she was given the Warren E. Berger Award for Excellence in Court Administration by the National Center for State Courts. It is uniformly known as the highest award you can give in this area. A formal... For those of you who know her, here, Patty. A formal presentation is set for early February, and you're all invited. Please, in closing, I hope I've given you a glimpse of a judiciary which is dynamic. A judiciary whose members are constantly striving to improve their competency and efficiency to fulfill their duty as the independent third branch of government in this great state. Thank you very much.
Roger. Roger, Chief Justice Burdick, we appreciate your comments. We appreciate all the hard work the courts do with their limited resources. We do recognize that, and we look forward to working with you to address these concerns in the future. Thank you again. Thanks. Before going on ease, the House was at the 15th order of business announcements. The House is at the 15th order of business. Are there further announcements, good gentlemen?
22.
22.
Thank you, Mr. Speaker and members of the House. The Majority Caucus will meet at 3:30 this afternoon.
Good lady from 29.
Thank you. I want to remind all the legislators of the ISU reception tonight at the Grove Hotel, the Evergreen Room on the second floor, and it's from 5 to 8, and we hope you all will attend. Thank you.
Good gentleman from 5. Clerk may read.
Following are the standing committee meeting announcements. Agricultural Affairs Committee will meet this afternoon at 1:30 East Wing 42, Andrus Chairman. Business Committee Subcommittee will meet upon adjournment of the House, East Wing East 408, Youngblood Chairman. Environment, Energy, and Technology Committee will meet this afternoon at 1:30 East Wing 41, Raybould Chairman. Local Government Committee will not meet this afternoon, Barrett Chairman. Transportation and Defense Committee will meet jointly with the Senate Transportation Committee this afternoon at 1:30 in the West Wing, Room 2, Palmer Chairman. For tomorrow morning, Education Committee will meet tomorrow morning upon adjournment of the House, East Wing, Room 41, DeMordaunt Chairman. Health and Welfare Committee will not meet tomorrow. Revenue and Taxation Committee will not meet tomorrow morning, and State Affairs Committee will not meet tomorrow morning.
The gentleman from 6.
Thank you, Mr. Speaker, for a personal privilege.
The gentleman has the floor.
Thank you, Mr. Speaker. This is just a reminder to all of you who, like me, may be a little bit behind. Today is the last day to submit personal bills. They need to be read by our calendar. They need to be read across the desk tomorrow morning. So they need to be in Bonnie's office before close of business today. Thank you, Mr. Speaker.
Thank you, good gentleman. I was glad that comment was not about the weather. Are there further announcements? Hearing none, the House will now advance to 16th order of business adjournment. The House is at the 16th order of business. Good gentleman from 13.
Thank you, Mr. Speaker. I move that the House to now adjourn until Friday, January 25th at 8 a.m.
Mr. Speaker.
Good gentleman from 6.
Mr. Speaker, I second the motion.
You've heard the motion. All those in favor say aye. All those opposed say nay. The motion is passed, and the House is adjourned until the hour of 8 a.m. Friday, January 25th, 2013.